I think there's some language that might be a little bit broad, but at bottom, Griffin's case is about a collateral habeas proceeding. And Griffin had brought his case after the fact. He needed a cause of action. Why wouldn't it work in a trial for him to challenge Sheffy's constitutional ability to adjudicate his case?
What Griffin's case holds is that only Congress can provide the means of enforcing Section 3. And under Your Honor's hypothetical, Congress has not enacted any such statute that would give Mr. Griffin the right to raise those types of arguments at his trial. So he would have to await legislation from Congress.
Okay, let's assume that I disagree with you about the officer argument. So Section 3 covers President Trump. Let's say that Congress enacts a quo warranto provision that would allow a state, or I guess it doesn't really matter for this purpose, even a federal prosecutor, to bring such an action against him, to remove him from office in the quo warranto way. Wouldn't that be in some tension with impeachment? He would be extracted from office outside of the process of impeachment. Couldn't then President Trump simply say, well, the only way to get me out of office is the impeachment process and not this quo warranto action?
So I don't know how that would play out, because the quo warranto actions that were brought, that I'm aware of, under the 1870 Enforcement Act were brought against state officials. And Your Honor's impeachment hypothetical would apply not only to the president, but any federal officer of the United States.
I know.
So I don't know how that played out in the courts and whether anyone ever tried to argue that impeachment was the exclusive remedy for.
Well, I don't think anybody did argue it. I guess what I'm asking is, you said it's Congress's exclusive province.
Yes.
And you also said that it has to apply, after one is holding office, is elected. And I'm asking whether then the implication of your argument is that Congress could not enact such a provision that applied against federal office holders that were covered by Section 3 as opposed to state ones.
I believe they could. And the impeachment clause says that the president, the vice president, and all civil officers of the United States shall be removed from office upon impeachment and conviction. But it doesn't say that's the only way you can remove them. I mean, Congress can defund a position, and effectively, it's not quite the same as formal removal. But the other relevant precedent is Stewart against Laird, when the Jeffersonians repealed the Midnight Judges Act and abolished all of these positions for federal judges. And some people thought that was unconstitutional because they thought the only way you could eliminate federal judges was through impeachment. But Chief Justice Marshall upheld that statute. So that, to me, is a relevant precedent showing that impeachment is not the only way to get rid of a federal official.
Okay, let me just ask one question, and this is just a point of clarification. Does President Trump have any kind of due process right here? I mean, I'm wondering, this kind of goes not to the cause of action point or the preemption point, but more to the question of what procedures he might have been entitled to. You don't make the argument that he was entitled to any, nor did I see the argument that he had any kind of constitutionally protected right to ballot access, so that he was, and constitutionally entitled to an opportunity to be heard. Is that right? He had no due process right?
We made that argument below. We did not make that in our briefs to this court for several reasons. I mean, Your Honor's, I think, suggesting, and this is correct, that the proceedings below, to put it charitably, were highly irregular.
Well, I wasn't suggesting that. I was just asking.
I'm sorry. The question seems to suggest that there might be due process issues, but we didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling. We didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling specific to this particular proceeding in the state of Colorado and would leave the door open for Colorado to continue on remand to exclude him from the ballot.
Okay, thank you.